Thanks very much, everyone, for being here today. Before we begin, on behalf of the panel, we'd like to collectively acknowledge Ngunnawal and Ngambri peoples and offer our heartfelt respects to elders past and present. And in that vein, I'd also like to acknowledge the passing of Auntie Roberts earlier this week. I did seek advice from Auntie Eileen, who says that I can use her surname, but not her first name because she's just passed, but to acknowledge the extraordinary influence she's had in coining the term welcome to country. I'm very pleased to be here on this panel on law and civil preparedness. On one hand, law is this nerdy, abstract, dry thing that people like James, Dominique, and myself like to carry on with. But on the other hand, it actually sits at the crux of how we do policy. Law is how we enable and restrain policy. The way we communicate about law is also really important to how it's received by the public. For example, recent legislation around hate speech has produced some confusion in the community, particularly because of inconsistencies between state and federal legislation and the rushed manner in which these laws were made. I know myself, I've had multiple queries from members of the community asking me what they can and can't do. And even though many of the things imagined in the legislation aren't actually contained in there, it nonetheless has a chilling effect on the community and can become a proxy for concerns about legislative overreach and trust in government institutions. So we're not just talking dry statutes, we're talking about how we do the doing. So I'm very pleased in that context to be joined by two of the best experts in national security law that you can find around, and that is the Honourable Professor Judge James Renwick, who of course is, although a member of the bench, I just commented that James hangs around on benches, but not park benches, much more formal benches. But of course, he's here very much in his personal capacity today. He is a professor in practice, an adjunct professor at the National Security College at ANU, and he's had an esteemed career, including as a Fulbright scholar, but also as a very well-known and accomplished barrister and a former independent national security legislation monitor who oversaw a number of important reforms and inquiries. He's also carried on a number of cases relating to constitutional law, both here in Australia but also in Papua New Guinea, and is familiar with a lot of the legal and cultural challenges facing our region. I'm also delighted to be joined by Dominique Dalla-Pozza, who's a senior lecturer at the ANU School of Law, but I'm also very pleased to say she's also part-time us at the National Security College. It's hard to imagine someone who has a better understanding of parliamentary procedure and the role, for example, of parliamentary committees in making sure our laws are up to the job and that they have the appropriate accountability mechanisms. And that's obviously a hugely important thing in a jurisdiction that doesn't have a Bill of Rights. Committees play a really important oversight function, and maybe we can get to that a little bit later. I think it would seem rather odd if I read out my own bio, so I'm not going to do that. Other than to say I'm an associate professor here at the ANU National Security College. I've been in the academy about 15 years. My areas of expertise are constitutional law and international law, but I've also worked in the New South Wales, Queensland and federal governments as well as in the private sector. So I have lots of opinions, I can tell you that much. What we're going to do is we're going to start off with a 3-minute opening statement to sort of throw our ideas out there. Then we're going to have a 3-way conversation where we unpack some of the details around some of the issues facing us in a law and civil preparedness context. I think as someone observed yesterday, we should think about civil preparedness in the way we think about disaster resilience. We may not be able to stop the cyclone, but we can prepare for it. So in that note, can I ask you, Judge James, but of course in your personal capacity, to give your opening statement?
Yes, thank you very much, and I'm delighted to be here. So let me look back a little before we look forward so that we have some perspective of the potential width of civil preparedness and national resilience laws. And the handout I've given you all is Section 5 of the National Security Act of 1939, passed following just 11 hours of debate in 1939. And with some exceptions, for example, not having industrial conscription or forcing civilians to be subject to military discipline, the Commonwealth gained regulation-making power under that Act, which, as official historian Sir Paul Hasluck later wrote, were as extensive as the prosecution of the war itself. The law also was part of the plan set out in the old war book, whose purpose was said in that history to be, quote, to provide a record of all measures involved in passing from a state of peace to a state of war, or, for present purposes, a state of ultimate civil preparedness, and to return to the quote, to ensure that all authorities in any way concerned with the defence of the Commonwealth should know the precise measures required of them at each stage in the process, and that the actions of the defence services and departments were closely and continuously coordinated. And there ends the quote. Criticisms of that 1939 Act at the time focused on its huge impacts, obviously enough, on democratic rights and freedoms, including by greatly reducing parliamentary oversight by the Parliament of the executive branch. Of course, Australia is a very different place now. It's a more complex place, and there are different forms of oversight. I encourage you to take the handout away. The breadth of Section 5 is extraordinary. Looking forward then, one of the many tasks of this conference is to encourage a conversation not only about what powers are needed for civil preparedness, but how safeguards can be built in from the beginning. And we must, of course, accept that some threats simply can't be foreseen because they can't be known in advance. So that is a tiny amount of historical perspective to start the discussion today.
Thank you, Danielle. It's such a pleasure to be here on this panel with you and with James. So I'm going to start by talking a little bit about what I gleaned from reading the executive summary of the NSC's community consultation report. And in particular, I was struck by the following, and I'm starting to quote now. In our focus groups, security agencies were generally described as credible, professional, and mission-focused. Politicians and media, on the other hand, were often seen as having a vested interest in exploiting security issues for advantage. And there ends the quote. There was also much discussion in the executive summary of a feeling of of the Australian people not having enough trusted information for people to be able to think about the security challenges facing Australia. So as somebody who is committed to Australia's democratic and legislative institutions, the findings, those particular findings of the Community Consultations Project have further catalysed my thinking about the work that parliamentarians do, and in particular how that work is understood and communicated. I think it's a crucial area of preparedness that people understand how they can constructively engage with their elected representatives to help make us all safer.
That's great. And just to add my own 2 cents to our 3-minute openings, I would say that the world has changed a lot, to risk stating the obvious, since the last time we were in a global conflict, a world war. So, for example, state and federal relationships are different. So the way we mobilised last time will look very differently today. The other thing that's since happened since World War II is a greater recognition of human rights. So, for example, we have the international treaties now, but we have Australian human rights legislation. And, for example, the existence of the implied freedom of political communication didn't exist at the time we last had a war. And also, my view is that the freedom of religion would be interpreted very differently. So the way we mobilise will be very different. And a couple of other factors just to bear in mind is, of course, we're at 2 minutes to midnight in terms of climate security. 2025 was one of the 3 warmest years in history, and the 11 years prior are the 11 warmest years in recorded history. We've got increases in hate speech, not just against the Jewish community, but including the Jewish community, but also the Muslim community, and also against First Nations people since the Voice referendum. That's been a real problem where leadership has been lacking. Also, we know about radicalisation of young people and the risk of mixed ideologies, of which misogyny is playing a huge part. So the landscape we're in is socially, culturally, and legally more complex than it used to be. So that's my opening pivot. I then turn to you, Dom, for a question. In all of what you've said and how we've just situated this, how important is Australian lawmaking and law reform processes to ensuring civil preparedness and, dare I say, potentially mobilisation and social cohesion?
So I would say very important to all of those things. And it's because that in our liberal democratic system, it's really important that we can rely on the laws that are made in open democratic processes that clearly set out the powers and limits of what our agencies can do and cannot do to keep us safe and ensure preparedness. And where I start my thinking on this is in an observation made by Dennis Richardson when he reviewed the legislation that supported the national intelligence community in 2020. And he made the observation, and again I'm quoting, that enacting and implying legislation requires greater transparency, scrutiny, and democratic deliberation on executive than relying just on executive powers. And he mentioned that exercising these powers under statute is susceptible to more effective forms of judicial review and other forms of oversight than simply relying on executive powers. And so it's that balance there of being able to see what laws we have and to be able to keep looking at them to make sure that they are appropriate to our current situation that I think is so important. And so I'm invited by you, Danielle, to talk a little bit more about one of my favourite subjects, which is parliamentary committees. I promise it's not boring, but one of the things I wanted to highlight today is the work that the Parliamentary Committee has done in conducting a review at the beginning part of this year as part of its oversight into how state sponsors of terrorist groups are listed by regulation. So that was legislation that was passed at the end of last year that allowed state sponsors of terrorism to be put on lists, which then had a series of potential criminal law consequences that followed from that. What I find to be particularly interesting is that there is a role for the Parliamentary Joint Committee to review that making of that regulation before the body is put on a list. And this process allows members of the public, community groups, to talk directly to their elected representatives to explain why a listing is a good or bad idea. Now, in the case of this particular report at the beginning of the year, it involved the Islamic Revolutionary Guard Corps in relation to Iran. And it was a really interesting report in terms of the fact that it is a public endorsement of the government's decision to list this agency, and they received a substantial number of submissions. The report said that they had received 180 submissions to that review, which included 48 confidential submissions and 99 submissions where the submitter requested that their identity be withheld. And so these are people who are still under considerable pressure, but still engaging in the Australian political process to say that we agree with what the government has tried to do and we understand how these laws are being used. And so I would just commend that parliamentary committee process to everyone. It's not as well understood as I would like it to be, but it's a really important way in which our democratic systems check the other powers in our legal system, but also a great opportunity for people in the community to speak to our elected representatives to help them understand how security threats are real for them. And so this is the sort of work that I hope that more people in the community understand. I'd like it to be more visible, and it would be seen as a source of trusted information to help counteract the feelings of uncertainty as we move forward into the next few years.
So write your submissions now.
Write your submissions now. Yeah. So that's really what I want. What I wanted to talk to you today about.
Fabulous.
Yep. And it's, I think, my turn to ask James a question.
I think that's right.
So it is, in the context of social media regulation, how can law promote social cohesion and reduce disinformation?
So I'm sure no one here needs convincing about the pervasive impact of social media and its potential to promote disinformation and to be used often deliberately to unpick Australia's social cohesion, or worse for that matter. So let me deal with two types of those who post on social media, accepting that there's other categories. First, there's the small group, the use of social media by a human being in Australia who's identified or is at least identifiable. In this case, their motivations can be questioned, their message responded to, and if there is, for example, evidence of breach of the law of defamation, racial vilification, incitement to violence or foreign interference, to take only 4 examples, Australian law can take its course. But also, of course, there's the social media poster, which is either not human, the creation of a bot or artificial intelligence, or is human but is controlled by or working for a hostile nation state or criminal organisation outside Australia. And you would have heard the Commissioner of the AFP speak about that yesterday. Obviously here ASD plays a leading role. So let me summarise some suggestions I'm aware of for responding to these two groups. First, there's the role of international law in setting the rules when foreign states and actors engage in disinformation and grey zone activities, which amount to cyber warfare, and which at their most extreme can amount to an armed attack justifying self-defence by Australia as permitted by Article 51 of the United Nations Charter. There will always be problems with attribution, but we're getting better at it. Secondly, and this is quite often done by the FBI, one can announce an intention to take action against individuals and identify them, even if they'll never be extradited. It sends a powerful message and shines sunlight on the problem. And third, and I have in mind here the example of the US Naval War College Blue Book on computer network attack and international law, one can encourage the publication of opinio juris by scholars on the topic. Even if the sources and methods can't be mentioned publicly, the effects being prescribed can be clearly stated. And by groups of scholars stating the rules, the limits of lawful action can be established. Perhaps that's our next conference at the NSC. Two other short examples. Next, while a law seeking to make governments the arbiters of disinformation must be careful to avoid infringing the freedom of political information, which you've spoken about. It may be much easier to require the real identity of social media posters to be revealed. After all, if the law can require evidence of the age of users of social platforms, presumably it can, whether it should is another matter, but it can peel back the mask of anonymity and also identify again whether the poster is human or not, or onshore or not. And you may have heard the former Electoral Commission say there's arguments both ways, but electoral law is an example of where people are required to identify who they are and the electoral statement. And the final short point, and this picks up on something the AFP Commissioner also said yesterday, is the careful use of official information. As I said when I was insular, one often overlooked reason for governments publishing information proactively is to prevent or correct error and forestall mischievous speculation. In a world where malicious actors propound fake news, unnecessary secrecy can be seriously counterproductive. And the government statements could be regular, indeed routine, factual official updates about what government agencies have done, as well as required, specific rebuttals of disinformation. Thank you. And now I am going to ask the question. So what lessons, Danielle, on civil preparedness can we learn from the Australian response to the COVID pandemic and from our response to major floods and fires?
Well, thank you for the Dorothy Dixer, James. Before I get to the issue of lessons to be learned from floods, fires, and pestilence, I just want to say I appreciate I'm fighting a losing battle here. But just to make the point that the term social cohesion, as we've been using it throughout this conference, I think is quite problematic. There are a lot of communities that see cohesion as synonymous with autocracy, right? Like authoritative dictator-type societies are very cohesive. And I'm just going to offer up the suggestion that the term peaceful pluralism might be a more useful term. And well, what's that got to do with the law? Well, I think we've seen in reaction to recent laws restricting protests, and, by and large, I support the laws. Of course, the freedom of speech is not an absolute right. It needs to be balanced with the rights of others to be safe. But the problem is the term social cohesion has been used to communicate that to the public, and it's now become a proxy of something to protest against because it looks authoritative. So I'm just going to put that for the record. I know I'm fighting a losing battle, but I think what we're actually after is peaceful pluralism rather than cohesion. But to answer the actual question that you asked me, so there are a bunch of inquiries in relation to the handling and governance and legislating around the pandemic and around floods and fires. And you can read those reports for yourself. But in sifting through them myself, one thing that really stood out to me is relationships between the Commonwealth and the states in because of how our federalism works, was sometimes really problematic. So one of the advantages of Australia being a federalism is that it allows for contestation of ideas and for local government and state governments to be more responsive to local issues. But you do get buck passing. And one thing in my own experience of the community consultations when I was on the road, one thing I was hearing a lot is that there's not always a common entry point for discussions with the states about national security. So what we heard on the ground was that states wanted more information on national security, but also frustration about agencies not knowing exactly who to talk to. Now, I did put that question to someone yesterday and it was sort of brushed off as, oh, that's the job of Premier and Cabinet. But the feedback we got is that it doesn't always work that way. And I think our model of preparedness in a constitutional sense would benefit actually from improved Commonwealth state communications around national security. But also I'd suggest that there's this thing called the implied nationhood power, which is probably underutilized. And it's implied because it's not actually written in the Constitution, but it's been held that it's implicit in there. And I think the government could do more to use that power in terms of responding meaningfully to the existential threat posed by climate change, and also probably in the context of mobilisation. And I think that's a really important lesson to learn there. The other thing to note is that the studies into the COVID pandemic looked at public trust. And public trust was actually really high. You know, Australians, we like to see ourselves as a bit rebellious and sort of, larrikin, but actually we quite like rules. And by and large, people had high levels of social trust and were happy to do what was asked of them when it was communicated. So there's a lesson there. But trust declined dramatically when there started to be inconsistencies in responses. When Queenslanders were out at restaurants while Victorians weren't allowed to use the swing down the road. And so there's a lesson there in terms of how our federation works. Now, there are legal mechanisms, as most of you probably know, that allow Commonwealth laws to trump state laws to a certain point, but the states are constitutionally protected. Their existence is protected. And so rather than wait until we're in the middle of a crisis and we're having to do mobilisation, we're having to do preparedness, those conversations and mechanisms need to start now. And I know there's been so much great work in this space that's happened in recent times, but I think that there's more to be done on that. The other thing that you can take from looking at that is that we actually rely on our ADF a lot, right? I'm sure everyone had a flood or a fire or a pandemic experience that involved the ADF. There are 43,000 people in the Army. Someone mentioned yesterday, it really struck me, that's less than half of the MCG, right? And so we're asking our ADF as a whole, particularly our Army, to do so much work. And we're, potentially, hopefully not, but we're potentially on the doorstep of a regional global conflict. Again, hope not. But if we are, then I think it's time to start paying more attention to what our armed forces are doing. They're doing so many incredible things, and that's not actually being translated into the community better. Now, again, what's this got to do with law? It's got to do with how we're communicating law, and about getting the public used to the kind of legal mechanisms that will need to be employed if we are coming up to a scenario where we need to mobilise properly. And I know mobilisation is a different word to preparedness, and they are two different things, but it's about time we started to use the M word. As I said earlier, the freedom of religion that is in our Constitution was interpreted earlier as not protecting a person from, for example, conscription. My sense is that might be decided differently today. Not that we're talking conscription anytime soon, but there's a human rights framework that the government might encounter when it's seeking to use emergency powers or to use its executive power to enter into an armed conflict. Because, of course, you don't need permission from Parliament to enter into an armed conflict in Australia. That's decided by our executive arm of government. But there's so much legislation that flows from that. So, for example, if the Commonwealth needs to acquire buildings so that we can produce more uniforms or we can produce more munitions, there's a constitutional power that allows for a building or a property to be acquired for that, but it has to be given on just terms. In terms of public trust, it matters not as much what the law says and does. Of course, that's important. But the way the law is communicated is equally important. There are conversations we need to start having now about what those laws and mechanisms will look like. And that's something we can get on, again, to borrow the phrase from yesterday, we can't always stop the cyclone, but we can certainly prepare for it. Do any of you have any final comments on any of that or any of what we've discussed today?
Just to say that, again, a theme in the session that I've just been to is the importance of increasing civic and democratic literacy.
Yeah.
We talked in that session about particularly the online spaces, but I think it's also important to see what's happening in the real world. So Parliament and the parliamentary committees exist in both places. They exist in person and in real time, but they also have an online presence. So I am keen to see how my work can feed into helping us all to understand a little bit better how our parliamentary mechanisms work and pushing back a little bit on the popular perception of this all being about politics. There is, of course, a political element to this, but Parliament is engaged in its oversight and legislative work for the benefit of the country, and I would like to see that side of it more, but better understood.
And of course, we all know that famous statistic, right? Talking of civics literacy, when surveyed, 60% of Australians thought we had a Bill of Rights. We don't. We're actually the only Western democracy not to have one. There's a couple of rights scattered throughout the Constitution. But when asked to give examples of what those rights were, people said things like pleading the fifth, right? So sometimes civics literacy is coming from American television, and it doesn't need to. We're a rich liberal democracy ourselves. We've got an incredible society. We're an incredibly successful multicultural democracy. We can draw on our own story and narrative in improving our civics literacy. But I suppose even as lawyers, we have to concede that sometimes law is not the only response. We can't regulate ourselves out of everything. And sometimes there's this desire for governments to look like they're doing something. So we hyper-legislate, we pass all these legislation. We know there are over 800 secrecy offences, for example. And so sometimes we're just looking at an issue right here and forgetting the law of unintended consequences, where we've actually created a whole ecosystem that is greater than the sum of its parts and not necessarily in a good way. As a former insular, what's your response to that sort of need to regulate everything when perhaps the answer is not always more law, but better law?
Just to quote my great predecessor, Brett Walker, who said, in Australia, we see a problem and we think we solve it by passing a law, but perhaps that's not the way to look at it.
And where do you see most of the risk coming up around that at the moment?
Well, it's just something I said often as Insulam is that it's better to have a carefully thought out law with its safeguards prepared, and if not enacted, at least an exposure draft in times of tranquility, rather than drafting things in a hurry in times of crisis.
Absolutely. Justice must not only be done, but it must be seen to be done. Thank you, James. Thank you, Dominique, for the conversation today. It's one that will be ongoing. National security law is like a tightrope. Getting it right, you've got to keep it taut. So national security law is a verb as much as love is a verb. Thank you for being here today.
Thank you, Danielle.